day. How are you?
And Mr. Wilson, I'm putting off an information for arraignment. I'll note that you're seeking to represent yourself, and so we'll address that in just a moment.
He's the best dressed.
We're just reading this. The courthouse. I'm the defense attorney that's here today. I'm not going to be over here to you. Or the defense commissioner is going to be over to you. They're going to require that I do this. They can't.
Your Honor,
Yes.
at this point, Mr. Wilson does not agree to me arraigning him. He wants to be able to arraign himself.
Okay, very good. Thank you, Ms. Johnson.
Yes.
I'll just have you be present in the back if
Yes, Your Honor.
Okay. So, Mr. Wilson, I printed off an information. I just want to make sure that everything on it is correct. So, is your first name Cameron?
Well, on the information sheet itself, Your Honor, if I may,
Yes.
is spelled with all capital letters. My name is Cameron James Wilson with proper spelling.
Oh, and middle is James, is that correct?
That is correct, but it's not in all capital letters. This CAM with all capitals, Cameron Wilson would indicate your corporation, which I am not. So I just want to make that clear.
Okay.
So that information is incorrect as far as the spelling is concerned.
Very good. Ms. Johnson, can I have you grab the,
Yes, Your Honor.
the information and bring it up to the court?
Of course.
I'm going to amend the information to add the middle name of James. So that is amended. I'm going to initial and date that. And so I do note the objection as to capitalization of the name. And then is your date of birth February 5 of 87?
That is the date in which a document was wrote for my birth, but not my birth as far as life is concerned, conception of life.
Oh, and so what is your birthday?
Well, you would have to ask my mother and Almighty God. I wouldn't know the exact date and time and hour of whatever time is referenced in relation to my creation.
Okay, so the record will reflect that Mr. Wilson can't state his birthday. And then turning to interfering with the peace officer, sorry, sir?
Just an objection. I did state that there is a document claiming 2587. So that was the date of birth, but not my conception as far as life is concerned.
Oh, okay, date of birth was 2587.
Yes,
Okay.
sir.
So count one is interfering with the peace officer. It reads the defendant on or about May 9, 2025, in Marion County, Oregon, did unlawfully and knowingly act in a manner that prevented Officer D. Francisco, a person known by the defendant to be a peace officer, from performing the officer's lawful duties with regard to a criminal investigation. That is named misdemeanor, carries a maximum penalty of 364 days in jail, $6,250 in fines. And so, sir, you have a number of rights, as you're likely well aware, as regards to this new case. You have the right to an attorney. If you can't afford one, one could be appointed to represent you. If you could afford one, you could hire one to perform as an attorney for you. And I can see through the waiver of attorney form that you're asking to represent yourself. Is that correct?
Well, I wouldn't be representing. I would be presenting myself, though, Your Honor. Yes, sir.
And so can you tell the court what you think the distinction is between presenting yourself and representing yourself?
Representing would be having someone represent myself. I'm coming to the court as far as sui juris and propria persona to present myself as far as all of my creator endowed rights.
Okay. And do you have a law degree, sir?
No, sir. I'm not construed in the law whatsoever, so I would like the court to take judicial notice of the fact that everything I do say must be taken and construed liberally.
Okay. And have you ever represented yourself before?
Yes, sir, I have.
In a criminal case?
Yes, sir, I have.
Okay. So then you have some understanding.
Or should I say again, present? Because the represent and present are two different things.
Okay, the record will reflect that you would like it to be referred to as presenting yourself.
Thank you, sir, Your Honor.
And so there are a number of things an attorney can do for you that you have not been trained to do and may not know how to do or what to look for. The first thing an attorney can do is receive discovery and begin to review it to identify weaknesses or strengths in the state's case. Once they've done that with you, they can start to send out investigators to speak to folks, potentially take reports, use those to negotiate or ask for dismissal. I see you already have a motion for dismissal in your file. So if you wanted to improve your motion, an attorney could review that, make it conform with state law, and then use their investigators to try and find additional evidentiary supports to improve the strength of your motion. Without an attorney, you will be at a significant disadvantage at a pretrial posture. Do you understand that?
Well, I don't understand anything as I stand under nothing. I do comprehend the statements that you were giving and reflecting onto the court record. But what I will have to say too is just in regards to the aspect of saying that an attorney will improve anything that I'm doing, shows a little bit of bias and prejudice on the aspect that an attorney of some sort, as far as a representation, may be better than me as far as all of my full capacity, as far as my self-governance and right to self-govern in and of itself. So I'd just like to reflect that onto the court.
Okay, well, sir, you just indicated that you don't understand anything when I was asking you about what an attorney could do for you prior to going to trial.
If I may.
And so when the court is indicating that you might be at a disadvantage, it's because an attorney will have training and experience, will have been doing this for a number of years, and so they will understand the common procedural barriers that are going to be facing you. They'll be able to give you advice on how to surmount them and also talk to you about other obstacles that might be completely invisible to you right now.
For sure.
Without having an attorney.
Most
so that's
definitely.
the first thing I wanted to impress upon you. And that's one of the disadvantages that you'll be at, is because since you've never been in this posture before, or as you've indicated, you've represented yourself previously, but you don't have that legal training, even if you've represented yourself once or twice before in different cases, possibly in different jurisdictions, that doesn't mean that you're going to be able to see all of the different obstacles that are in your path in this particular case. So that's a disadvantage that you'll be facing if you don't have a lawyer. Do you understand?
Again, Your Honor, just for clarification, just so we get a clarification of the word in itself, understand, I do not understand. In my aspect of the knowing of that definition would mean that I'm standing under something. I will say that I comprehend everything that you are saying, logically, intellectually as well. I don't need assistance in any manner. I think I can handle my own creator endowed rights. And
Okay, do you comprehend that a definition of the word understand is to fully comprehend the information that's being provided to you? It's not necessarily...
in that context, yes, sir.
Don't interrupt the court. It's not necessarily a literal statement about standing beneath something, such as you are standing under the ceiling right now. Sometimes understanding also means comprehending information that's being provided to you. Do you comprehend that?
I do, Your Honor.
Okay. So I want to make sure you comprehend your rights and comprehend the things that are happening in court before I allow you to represent yourself, because you do have a constitutional right to represent yourself, but you are placing yourself in tremendous jeopardy by doing so, because again, there are a number of pitfalls and things that you won't know to look for that an attorney can assist you with. An attorney might also have access to resources that you don't, such as investigators or perhaps ways to try and secure experts to work on your case that you won't have the ability or knowledge to do on your own. And so those are some of the concerns I have just before we even get to the trial phase. Do you comprehend that?
I do, Your Honor. And
Okay.
again, just for the record, I will not be representing myself. I will be presenting myself in all matters.
Okay, great. And so the next thing that an attorney could do for you is negotiate your case. They could call up Mr. Kummerman or whoever the attorney is on the case. Mr. Kummerman, who is the DA on this case?
Nicole Mira.
Mira. Okay, so they could contact Ms. Mira and start to talk about your case. You have a motion to dismiss. They could start to impress upon them whether or not that was appropriate or try and seek out the best possible resolution for you. And then if you were choosing to go to trial, they could assist you with preparing your pretrial motions and give you advice on whether you should have a jury trial or a judge trial, because ultimately that will be a decision that you will make. You have a right to a jury trial. You can also have a trial before a judge. And so they will know the local judges. They'll be able to assist you with the process of assigning this case to a specific judge. They'll be able to give you advice on jury selection, jury instructions. And then as you actually move into the case itself, they'll be able to assist you with subpoenaing witnesses into court, documents into court. They'll be able to make opening statements for you, question the state's witnesses by cross-examination. They'll be able to question your witnesses after subpoenaing them. They'll give you advice on whether you should testify or remain silent. And then if you choose to testify, they'll be able to ask you questions that will allow you to provide your information in a way that is coherent and compelling. They will give you a better platform to stand on and make your message known than if you were simply speaking yourself, because again, they have that training and that experience. They will have been through the process before. Trial is an extremely stressful process. You're probably feeling some stress now, though maybe you won't because you've already been through this process before. But for many people, being in a courtroom is a stressful experience. And so an attorney will have less of that stress impacting their system because they've been through the process before, and they aren't the ones on trial, though they are coming with you into the trial. So they are better able to handle the stresses of trial and the different things that will occur at the last moment, because every trial has surprises and things that occur. And an attorney will know how to roll with that information and provide you with the best possible advice on how to deal with those circumstances as they occur. So do you understand that an attorney would also be a useful assistant for you as you move into trial as well? Do you comprehend that?
I do not.
Okay, so tell me what part of that you don't comprehend.
I don't comprehend that anybody would be better suited to help me defend my own matters than myself.
Well, sir, as I'm trying to decide whether or not you are knowingly waiving your right to counsel,
Most definitely.
the court needs to make sure that you comprehend the risks and the benefits that come with representing yourself as opposed to having an attorney assigned to your case.
I guess in definitions as far as what you see as risks or not would be on your own opinions. I don't see any risks from defending myself.
All right. Are you able to comprehend anything that I'm telling you about an attorney's ability to subpoena witnesses in a court?
I comprehend that I can subpoena witnesses on my own.
Do you know how to subpoena a witness in a court?
I do, Your Honor.
Okay. And do you comprehend that an attorney could give you advice on whether to testify or not testify?
I'm sure they could give me advice, and I comprehend that they could, but I don't think it would be best.
And do you understand some of the pitfalls that you could be facing if you testify yourself?
I do not see any pitfalls from me speaking the truth from the great Creator as the best witness of the statement of facts as they occurred.
Okay. And the court can't give you legal advice, so I'm going to stop short of giving you legal advice. But again, I'm trying to make sure that you understand that you are facing tremendous risk and you will be at a disadvantage if you represent yourself rather than having a lawyer by your side.
Well, Your Honor, first off, I'm Cameron James Wilson. I'm a living man, okay? I'm appearing here specially. I'm not appearing here generally. It's by special appearance only. It's number one. I'm not in the person for limited and express purpose of challenging the tribunal's jurisdiction here today, okay? Over my person and the subject matter of these proceedings, straight up. I appear here as a sovereign individual endowed by Creator and unalienable rights that predate and transcend any governmental authority whatsoever. I do not waive any rights, remedies, or defenses, whether procedural or substantive, whether at law or in equity. And I expressly reserve all rights under UCC 1-308, which is also codified in Oregon revised statutes. Before these proceedings advance any further, I must respectfully but firmly challenge this tribunal's jurisdiction in toto and move for an immediate dismissal of all charges based upon the fundamental constitutional violations and the complete absence of lawful authority to
I'll pause you
proceed.
there, sir. I'll pause you there. So the court has seen your motion for dismissal. It is premised in some ways on a motion to suppress. The court is not taking up motions to suppress today, so what I'm going to do is take that under advisement. That is something that a trial judge will consider at a later date.
Thank you, Your Honor.
At this juncture, again, has anyone threatened you to give up your right to have an attorney assist you on this case? Has anyone threatened you to make you come before the court and say you want to represent yourself?
There has been no threats whatsoever.
Okay. Are you under the influence of any medications, drugs, or alcohol?
No, sir.
Okay. And you also understood that an attorney could give you advice at the time of sentencing if you were convicted. Is that something you comprehend?
I comprehend, but again, I explicitly have expressed my rights, waiving my rights to any representation whatsoever. I do not need someone to speak on behalf of me. I'm not a ward of the court, nor am I an influence.
Court satisfied. So I'm going to grant your waiver. You can represent yourself. And then, Mr. Coomerman, I'm inclined to send this to a trial judge immediately. Anything from the state?
No, Your Honor, that would be the state's request.
Okay, so I'm going to assign this to a trial judge. Can we do that before? Can we make an exception?
Your Honor, I'd like to address a jurisdictional issue.
Go ahead.
So with all due respect, the jurisdiction is a threshold issue that must be addressed before any other proceedings can take place. As established in Steele Co. versus Citizens for a Better Environment in 1998, the court must establish its jurisdiction before proceeding to the merits of any case. have raised substantial challenges to this tribunal's personal jurisdiction, subject matter jurisdiction, and territorial jurisdiction. These challenges must be resolved before any plea can be entered or any other proceedings can take place. So I respectfully demand that this tribunal address these jurisdictional challenges before proceeding any further.
This court will make a threshold jurisdictional finding that this court has jurisdiction, reserving the right for you to develop your argument further. Again, finding that there are suppression issues that are attached to your challenge to jurisdiction. That'll be something that is considered by a trial judge at a motion hearing date. This case is assigned to Judge Armstrong at the downtown courthouse. Sir, I'm going to release you today with some conditions. They will include that you obey the law and that you attend your next court date. And then Judge Armstrong typically has court on Wednesdays at 1:10. Do you have a preferred number of weeks before you return for Judge Armstrong's court?
Yeah, I got depositions coming up next month. Let's see. I'm looking at mid-August until I'm going to be next available.
Okay, we'll have this come back August 13 at 1:10 with Judge Armstrong. That is without a plea at this juncture. And then, Mr. Wilson, if you change your mind, wish to hire an attorney, you're more than welcome to do so. You can always readdress the court if you apply for court-appointed counsel. And then, before you leave, I'm going to have you sign your release agreement with those terms. Again, obey the law, and make sure you come back to court for that future court date. I'll have you have a seat on the front bench.
Just one more, Your Honor.
Sure, go ahead.
I've had real trouble getting any kind of information as far as discovery or anything is concerned from Salem Police Department, risk management, and the likes. I would like to get an order, if available and possible, that you could give over to the state to go ahead and release discovery so I can go ahead and try and defend my matters in this case.
Okay, and I note that you didn't list the district attorney's office. I would encourage you to stay in contact with the district attorney's office. They should be able to provide you with reports. Now that you've identified yourself as representing yourself and the court has approved that, they should be able to release those documents to you.
Thank you, Your Honor.
And for the record, Your Honor, the defendant did try to address myself prior to the court today. I just looked through our internal file, which noted that he was requesting to represent himself, but wasn't allowed quite yet, or hadn't officially filed whatever he may have needed to do so. Obviously, now he has done so, so we can further those discussions.
Okay, so Mr. Wilson, I expect you'll get those reports immediately from the DA's office. If you don't, then you can readdress with Judge Armstrong a request for a motion to compel this.
Thank you, Your Honor.
I would lastly note, Your Honor, that unless there's some sort of electronic means established, the defendant would even personally come to our office at 555 Court Street Northeast, 3rd floor, to obtain that discovery. And there may be a delay in needing to redact certain information to provide him with a packet of discovery.
Okay, well, I'll direct the state to make sure that discovery is prepared as quickly as possible. And then, Mr. Wilson, you can talk to the state about retrieving.
Yeah, it's been a big hassle. I live, 4.5, 5 hours away, and the initial 2 charges that were brought forth were dropped, and then they just placed this interference. So it's pretty egregious. I think there's a big prosecutorial misconduct going on here. If we have to pursue any civil claims, we'll go from there. But I do appreciate the court today.
Okay,
Thank you.